Well, hello and good morning. Welcome to another Sunday morning coffee with Dr. Childress here. So today I'm going to be discussing court orders. What type of court orders should you and your attorney seek um, in to solve the problem? And essentially, it's a diagnosis. You want a diagnosis and treatment. You want to fix things. You want to identify what the problem is. Then you want to fix things. So let's talk about that today. The in all cases of a child rejecting a parent surrounding child custody conflict, a proper risk assessment for child abuse needs to be conducted to the appropriate differential diagnosis for each parent. So there's your statement. You can make that statement over and over and over again. We want a proper risk assessment for child abuse to the appropriate differential diagnosis for each parent. So, what is that appropriate differential diagnosis? Well, for you, your concerns are that it's a delusional disorder, that your ex has a persecutory thought disorder, a persecutory delusion, DSM-5 297.1. It comes from the collapse of into trauma, their unresolved trauma that distorts their thinking and perception. And they see dangers where none exist. And so that's the DSM-5 diagnosis you want assessed. But nobody assesses that for you. We'll talk to that in a second. The second DSM diagnosis is a factitious disorder imposed on another, a false attachment pathology. And you want them to say, the delusional disorder, you want them to say, no, this is not a delusion. It's real. The child's belief that they're being malevolently treated is true. Because if it's not true, it's false. It's a delusion. And it's a false factitious pathology. Or they can say, no, it's authentic. But then it's child abuse by you. But it's not child abuse by you. It's a false thing. Get them to say it's a false thing. Either one or both of those, or it's child psychological abuse. So here is the checklist, a simple little checklist that you can give to the court, that the court can then send to the forensic custody evaluator and say, please answer these questions. Is the targeted parent abusive in some way? And are they creating the child's attachment pathology? If so, identify the child abuse involved. So that rules you out or in, but you're not abusing the child. So get them to say that you are not abusing the child. And the moment you're not abusing the child, it becomes a false belief. And then we look at the delusional disorder, that the allied parent is psychologically abusing the child by creating the shared induced persecutory delusion and false factitious pathology in the child. So there it is. There is your differential diagnosis. You want a mental health professional to assess your family, properly assess your family, and answer yes and no to those two questions. Now, additionally, you can break it down even further and you could say, does the allied parent, your ex, have an encapsulated persecutory delusion regarding the targeted parent, you? And does the child share this persecutory belief, a fixed and false belief that the child is being malevolently treated in some way? There's a DSM-5 diagnosis. So yes or no. That's the job of the mental health professional, to diagnose mental health problems. This is a major psychiatric disorder defined in the DSM-5. We need an answer, please, from the mental health professionals. So get your court order to ask specifically for an answer from the psychologist to the psychological questions involved. The second component is it a factitious attachment pathology? Does the child have a false factitious attachment pathology imposed on the child by the pathogenic parenting of the allied parent. There's your DSM-5 diagnosis for that. And then the third is spousal psychological abuse. Is the allied parent using the child's induced pathology and the induced persecutory delusion, factitious attachment pathology, as a weapon of spousal, emotional, and psychological abuse of the targeted parent, of you? And there's your DSM diagnosis. So that's what you want answered. So ask the court to get an assessment from a forensic evaluator and who works in the family courts answering these questions. And if your attorney works for you, you need a zealous advocate. This is child abuse of your child and spousal abuse of you. You don't need a litigator attorney. You need a zealous advocate attorney who's going to the court and saying, Your Honor, this is child abuse by the a delusional parent over here. We need that assessed. And you say, I'm not delusional. Okay, fine. Let's get it properly assessed. And let's get it in there, get mental health eyes on it. And so that's up to your attorney to get these court orders. Now, if you're wondering how to diagnose any of that, I've got seminars up on YouTube. You can watch them. Diagnosing attachment pathology, diagnosing persecutory delusions, diagnosing child abuse in the family courts, and the DSM-5 diagnosis of the family court pathology. So I'm spoon feeding the mental health people what to do, what the diagnosis is. We just need answers to those questions. Is it child abuse by the targeted parent, or is it child abuse by the allied parent? Because if I've got a child seeking to flee from a parent, rejecting a parent, that's child abuse by one parent or the other. That's the only thing that causes a child wanting to flee from a parent is child abuse, either by the targeted parent or it's psychological child abuse by the allied parent producing a false, factitious attachment pathology to meet their own needs. So what's the diagnosis? So there's your descriptions of how to do that. Now, if you want to take it a little bit further, you can, because this is the overall model I recommend all the time, everywhere, for everybody, because this will get you a good supported diagnosis for the court. You will, each parent, litigant parent, is alleging the other one is abusive. The allied parent and the child's symptoms are saying the targeted parent is somehow abusing the child. The targeted parent is saying that's not true. That's delusional. That is a false, factitious attachment pathology. Well, then let's get that assessed. Each litigant parent, allow them to appoint their own second opinion consultant on this. The appellate system in healthcare for disputed diagnosis is second opinion. So let each one of them appoint their own second opinion to participate in telehealth in the assessment. Then you get the clinical diagnostic assessment with the consultation support. The court can then make its decisions and you can come up with a treatment plan to fix things. So there's your model for how to fix the family courts all the time, every case. So now the problem is, though, you're not going to be able to get that. So the court can order it, you can want it, but the mental health people in the family courts, your forensic psychologists, they won't give it to you. They won't meet the court's needs because they don't know how, basically. They're ignorant, incompetent, unethical. They're the worst imaginable. So if you ask them for a differential diagnosis, they're going to go, I don't do that. So you will be unable to get a diagnosis or treatment for your child, for the child abuse, for the delusional disorder, for anything involving your pathology, because that's not what the forensic custody evaluators want to do. It just drives me crazy here. So everybody else in healthcare, all the medical people, all the ADHDs, autism, eating disorders, everybody else in healthcare gets diagnosis and treatment, except you. You get something called a forensic custody evaluations. that are dangerous, harmful to children, and lack scientific and legal value. New York Blue Ribbon Commission. So you get the worst possible mental health services, and they refuse to diagnose the child abuse. And I know that to be a fact because I'm taking their course in how to conduct forensic custody evaluations. 7 days, 14 modules. I went through it, I've watched it, and now I'm in the process of developing the catalog of concerns for the course. And so I'll get that published up. You can see it's in preparation to get published up on Amazon. So you will see the catalog of about 20 concerns regarding what they do, the forensic custody evaluations. You do not want one. Do not get a forensic custody evaluation. They are awful. They are dangerous, harmful to children, produce defective reports with potentially disastrous consequences for parents and children. The New York Blue Ribbon Commission. I agree with the New York Ribbon. I've got 20 concerns that are substantial and that I'll be bringing forward more and more. We need to stop the forensic custody evaluations and meet the needs of the litigant parents and the court for a diagnosis. Which parent is causing the child's symptoms? Which parent is abusing the child? That's the answer we need. And you can go back to those initial questions. The problem is you can't get that because of something called institutional betrayal. That's Jennifer Freud out of University of Oregon. She's now retired and has a Center for Institutional Courage, which is the response to institutional betrayal. She's got several articles about that. I've got a blog currently up about Claude analysis of institutional betrayal in the family courts. I asked Claude to read the article by Smith and Freud. So here's the article, Claude, and describe it to me and relate it over to the family courts. Claude did. We got AI. So you can get an AI analysis of the institutional betrayal in the family courts. Plus, there's a couple of additional articles I'm doing up on my blog. One is about judicial betrayal. That's Gomez, Smith, and Freud for judicial betrayal. It's up there. It's an article about how the legal system betrays the victims of abuse. And then there's another article on the institutional betrayal by the American Psychological Association. That one had to do with enhanced interrogation techniques, institutional betrayal by the APA, institutional betrayal, judicial betrayal, and then institutional betrayal generally. It's a known thing. And that's exactly what's happened to you. The forensic custody evaluators captured everything, and they're doing what they want to do, but it's not meeting your needs. It's not the patient needs, the client needs, and it's not meeting the needs of the court for which parent is abusing the child. And they refuse to diagnose what the pathology, they refuse to provide standard health care of diagnosis because they can get away with it, because they do, because of institutional betrayal, because no one's holding them accountable, and they're ignorant, incompetent, and unethical, and that's why they don't do it, because the moment you ask them to actually do real psychology things, they don't know how. They're so ignorant and incompetent. You have to explain the pathology to them. Then you have to explain how to assess. These are the psychologists. It's just so bad in the family courts. But get the court to order the diagnostic assessment. And then they kind of have to do it if they're going to work in the family courts, because that's what the court is asking for. So in all cases of a child rejecting a parent, all of them, Surrounding child custody conflict, a proper risk assessment for child abuse needs to be conducted to the appropriate differential diagnosis for each parent. That just needs to happen. Please, it's child abuse by one parent or the other. Can we get that diagnosed and treated, please? There's your questions, yes or no. Get those written into the court orders, get them sent out to the custody evaluators and say, please assess for this. And they'll say, nope, not going to do it. And then you can go back to the court and say, we can't find a single psychologist to answer your questions, Your Honor. So you're going to have to make the diagnosis yourself, Your Honor. We'll present all the diagnostic criteria, and you can diagnose the delusional thought disorder, Your Honor, because we can't find a single psychologist to diagnose child abuse in the family courts or the psychiatric disorders in the family courts because they just refuse. And there's your second set of questions, more specifically. So with that, that's pretty simple. I mean, it's just yes or no. Get them written into the court orders. They the allied parent can get whatever they want assessed. You want an assessment for that they're delusional, that this is all a false factitious pathology, and you want a professional level diagnosis, DSM-5. There's criteria for all of this. And then it's up to your attorney to be a zealous advocate for you. This is child abuse of your child. This is spousal abuse of you. They should be fighting for you to stop the child abuse. And so get yourself a zealous advocate or represent pro se. If your attorney is going to be ineffective in protecting your child, well, you can be as ineffective as your attorney can be for a lot less money. So get your AI and start fighting to protect your child, or get an attorney who's going to agree to protect your child and start fighting for your child, and start getting these mental health people, to do what they're doing. So I'm doing everything I can. I'm telling you what it is. I'm spoon feeding the mental health people. I'm talking about the institutional betrayal. I'm trying to get them to stand up and do their jobs, but they're not, and you're stuck. And so start fighting, start bringing it out. So with that, I'm going to head off for my Sunday. Good luck to everybody out there. And next week is Easter Sunday, so I'll have a nice little Easter sermon for you. So with that, we'll talk with you later. Take care, everybody.